Chuck Krugel, and you're attending, I know what you did last summer, Workplace Investigations, webinar number 5. You can see on the slides, the entire PowerPoint, obviously. Slide 6 through 8 provides a summary of the series and this episode. Slide 4 is our disclaimer that you can't go out and make important business decisions based on what you learn here today. This is just general information. We're not your advisors or your attorneys, and you're not our clients. Also, we'll refer to the slides on occasion. We don't lecture off the slides, but we do follow through them and refer to them. So we'll point you out if that comes up on some of the slides. Our panels, as always, for the entire series is Max Barrick, partner at the Garfinkel Law Group, Helen Black, law offices of Helen Black. She's the main principal, and Amit Bindra, partner at the Prinz Law Firm. You can find out more about us on slides 39 through 42 of the PowerPoint. And as our host indicated earlier, we'll be checking out the question board. So you could submit questions live, or you can submit questions after the live broadcast to info@financialpoise.com. Just include your question, obviously, and the name of the webinar episode, and we'll do our best to get you an answer as soon as possible. Finally, thanks to our sponsors, the National Law Review. They're mentioned on or discussed on slides 3 and 43. With all that preliminary stuff out of the way, let's get down to investigations. So, Helen, we'll start with you. Who should conduct investigations for employers? Should it be the owner and the operator of the business, or should it be a third party? Should it be their own counsel?
So it could be any of the above. It really honestly depends on the situation, and each investigation really needs to be tailored to the situation at hand, which is why I say it could be any of the above. And let me give you an example of, in a way, all 3 situations. One where, let's say, an owner of a business could handle it. One in which, let's say, an outside investigator should be called in, or one where, let's say, HR or an attorney. And here's what I mean by that. So let's say you have a very, very small business. There are only a handful of employees, 10 or less employees. So it's going to be the kind of business that is not going to necessarily support an outside HR person. The owner of the business generally runs the company. Someone comes to the owner of the business and advises that, let's say, there has been some kind of an inappropriate situation. And maybe the situation really doesn't rise to the level of like a legal problem. So let's say, for example, 2 employees are merely bickering because they just can't get along. It's not because it's based on someone's a member of a protected class. It's not because of, someone committed fraud. It's just 2 employees can't get along, and it's causing disharmony in the workplace. The employer should still nip it in the bud. They should conduct an investigation, find out what happened, and take corrective action if need be in that situation. So there's one example of, let's say, where the employer on their own can conduct an investigation. Let's say it's the same situation in which we have a small employer, but it involves, let's say, really egregious conduct that can open the employer up to liability. I would say in that situation, it would behoove the employer to spend some money and hire an outside investigator who could be impartial and who can conduct an investigation. So let's say, for example, one employee alleges that another employee, let's say, grabbed a body part or something to that effect, and it's really something that is quite sensitive. I would say in that situation, especially if you're a small employer, hire an outside investigator, conduct an investigation, and nip it in the bud as fast as you can. Let's say it's a larger company that has their own in-house either attorney, HR, etc. And let's say it does involve something that's very sensitive. Like, let's say there's an allegation of, corruption or foul play or who knows what. In that kind of a situation, the employer and HR and legal should really discuss what is the best approach. In some situations, an HR person might be equipped to investigate, or maybe an in-house attorney might be equipped to investigate. But it could also be if you're concerned about impropriety or undue influence, then you should hire an outside investigator, because an outside investigator is going to, be hopefully, and that's why you're hiring this outside person, someone who is going to be impartial and conduct a thorough investigation someone who doesn't necessarily have, a vested interest in the outcome, meaning it's not their business. They're being hired to do a job, and they can be a little bit, they have an easier time being impartial than, let's say, someone who knows all the players in the company. So especially when there's going to be a situation where someone is concerned about favoritism and treating everyone equally, a default should be to hire an outside investigator. So the third situation that I mentioned before is that you have, let's say, someone from HR, or let's say an in-house attorney investigate. So let's say, you have a larger business and there is an allegation of, let's say, sexual harassment. And let's say it's even by a client or something. In that situation, it very well could be appropriate for an in-house attorney, or let's say an HR person, to conduct an investigation and a thorough investigation if that HR person is properly trained in how to conduct investigations. And also if the in-house attorney, very similar, is knowledgeable and has the wherewithal to conduct an investigation. So these are some of the different kinds of scenarios and situations, and it really is a case-by-case basis as to whether an owner should conduct an investigation, HR, an in-house attorney, or you retain an outside investigator for the investigation.
Some of what you discuss goes into criminal behavior. So I imagine there's also the possibility of calling law enforcement.
Yes, definitely. If something does involve criminal behavior, then yes, you might need to call the police, and you might need to also help the person report it, let's say, to the proper authorities. So for example, let's say it involves a client, and a client, let's say, committed a battery on one of your employees, then more likely than not, law enforcement should be called in.
Well, and to build on that, some municipalities and state, I mean, I think this is probably more prevalent at the city and municipal level, but you might see it at the state level as well, depending on where you live. But some professional licenses that you get or are required to have as an employer in business require you to engage in certain sort of reporting and cooperation with law enforcement. So for example, the city of Chicago, if you get a liquor license, not like I know this from case specific experiences. And there's a crime committed on your premises, you are agreeing as part of getting that license from the city to quickly and promptly report whatever misconduct has occurred to Chicago Police Department and law enforcement, and to cooperate and assist with the investigation, as needed. I mean, and within reason, right? Like there are obviously legal reasons you might push back at various points, but generally speaking, you are agreeing to cooperate. Now, that's just a local version that applies to, cases we might work on. But I would say, given that this is a national webinar, that's one more thing to consider, is what is required locally and license wise in terms of getting law enforcement involved. I know we're going to touch on that, I think, later, but it came up organically here.
Well,
Right, there could
yeah,
also be an allegation of, let's say, illicit drugs were involved,
Yeah.
and that could contribute to whatever was the nefarious conduct that happened in the workplace. If that's the situation and that comes out, certainly the company doesn't want to be in the position where it's hiding perhaps illegal conduct that took place in the workplace, and you want to nip it in the bud, and that could also be a reason for contacting law enforcement.
well, and you may have contractual obligations to report too, under grant funding or venture capital, or some sort of third party funding, to report to them or report to the authorities untoward conduct allegations, things like that. So I mean, I've seen it come up. It's not like in federal contract compliance, it doesn't come up often, but I think it's like a small sliver of some federal contracts or grant, well, especially private sector or not-for-profit sector grants. So yeah, you got to be careful. What about Upjohn versus US? That's mentioned on the PowerPoint slide number 31. It has to do with like the general counsel or attorney-client privilege, I think.
Yeah, so if, let's say, an attorney, an in-house attorney, or even an outside attorney is going to investigate, you have to make it very clear to the individual who is the subject of the investigation. What I mean by subject is not like they're the harasser or whatnot, but let's say they're the witness who's being interviewed. That's what I mean by the subject. They're the subject of the interview. that person being interviewed. If an attorney is going to conduct it, then the attorney has to definitely tell the individual that they don't represent that individual, they represent the company, and that they're not their attorney and that there is no attorney-client privilege. If it is an in-house attorney, let's say, then they have to let the individual know that essentially their client is the company and their communications could be privileged, but that privilege is by the company and not with the individual. So they have to be very careful in those situations and let the person know that I don't represent you. I'm not your lawyer.
In
So,
addition
thanks,
to
Howard.
that, though, I think
Yeah.
so everything Helen said is 100% right. The attorney has to tell the individual they don't represent the individual. But I think from the company standpoint, depending on the state you're in, there might be other nuances as to whether or not that communication is privileged. And so that's another layer to the analysis, is figuring out is that individual part of a control group? Is that going to be a privileged communication? How is that going to function? And so those are additional things then that the attorney kind of has to think through as well as to whether or not privilege is going to apply. On the
Thanks,
company
Howard.
side, yeah.
Yeah. Max, what are some elements of effective investigations? Are there some like simple common denominator type rules? And how long, like, and I think along that line, how long should they take?
Swing it. What's the harm?
Yeah.
No, don't. I gotta stop with these bad jokes. I think, stepping back, I think before we discuss like what makes the investigation effective, like what are exact steps, what's the timing, I think you need to start off with some goals and what to avoid, right? Like you shouldn't go into an investigation looking to prove a point. You need to go into it with an open mind and not looking for a specific outcome, right? So as an example, there was a case I worked on once that involved a bar, and the same bar I had a sex harassment client. There was another ongoing lawsuit where counsel for that bar had actually been disqualified from the federal case because they were the only witness to the investigation. They basically participated in a harassment allegation investigation. Then, I guess, in tandem with the owner, made the determination to fire this person for allegedly lying, but made themselves a witness in it. Now, it would have been my contention, looking at that set of facts and what I knew there, that that was something they were really always looking to have be the outcome. It was sort of this stated intention of, we got to find something to get her on. There's a technicality or a discrepancy in whatever video we have and what she's saying. We're choosing to interpret that as lying, and we're looking for an outcome here. And then they're going to turn around and use that investigation as a defense. So I think that's an example of what not to do. Don't go in looking to nail somebody or believe you're going to catch them in a lie just because you don't like that person or their report is inconvenient to you. So I think that said, more directly to what you're asking, promptness, impartiality, attention to detail and thoroughness and documenting are really the key core concepts that you want to focus on. You want to begin the investigation promptly. Don't take a complaint or a report of something and sit on it for weeks deliberating whether you want to look at it or not. If you think it's garbage or you think there's a reason for it to be maybe frivolous, that's fine, but you still need to look into it and treat it as if it's not. Because even if it's a serial complainer employee, what is it, Peter and the Wolf, at some point the wolf does actually show up. So every now and again, something actually does happen. And I had an old boss who said, when I was looking at a demand letter that I had to write, I was like, I think this client's kind of paranoid and a little bit off. And he goes, you're right, but crazy people can be harassed too. So do it anyway.
Yeah.
So,
Good point.
yeah. So I think that's one. I think you do want a trained investigator and ideally somebody who can be as impartial and neutral as possible. I think as a general matter, the notion of somebody who's just a blank slate is just psychologically an impossibility. But you can have somebody without relationships to the parties involved, whether that is a robust HR department with designated investigators who kind of keep their distance from those outside the HR department and can come in with clean hands, a third party firm, somebody that your counsel hires or otherwise, or somebody else in the company who can remain at arm's length. You want to make sure you have that person, ideally somebody with a background in investigations. You want to be careful about, we've talked a bit about, well, you want to bring somebody in. Sometimes it's a good idea to not use your existing general counsel, outside counsel for that, because for the reasons I just described, you may conflict them out of representing you if this turns into a litigation matter down the road, or create other evidentiary issues and start to imperil your attorney-client privilege if, for example, it's a harassment case and you invoke the adequacy of your investigation as part of a fair Growlrith defense or some other defense to the harassment allegations.
And we'll be getting into character hours down the line, so
Yeah.
we're not just going through those terms or throw them at you as window dressing.
Exactly. You want to make sure you do interview the complainant, whoever is being accused of whatever the misconduct is, and any relevant witnesses. In tandem with this notion of don't go in looking for a certain outcome, don't go in trying to prove a point. Don't, if you've got a sex harassment investigation, don't interview everybody but the complainant and her witnesses. Don't just, or who's ever. Don't just look for the witnesses that you think are going to support the narrative that your client or you want. Do a real investigation, really talk to people. Make clear they're not going to suffer repercussions for telling the truth, and we'll get to that as well. Make sure you follow up on open questions, requests for additional information. Make sure you're documenting what you do.
Just to clarify, open questions, not yes or no questions. Questions that elicit their talking their opinions about things.
Yeah, so in other words, I meant something different, but that is a good point.
Okay.
Don't go in leading, cross-examining questions.
Yeah.
Go in and ask, what is your experience with this person? Have you ever observed X, or what are your observations of this? Try not to lead them or give away too much. Leave it open enough where they have room to run and speak. But also, I mean, if you ask somebody something and they say, I got to check on that, I don't remember, or I'd have to go look, don't drop that stuff. If there are questions that come up in the course of these interviews that you follow up on with another witness, or to come back to an old witness about something new, do that. Close the loops. Make sure you don't leave anything open. And if there is remedial action called for and you do need to come to a conclusion, make sure you're willing to make a decision. If you can't conclude something because there's conflicting stories, document that, but maybe consider taking steps to remedy the problem, even if you can't prove it happened the way, so again, I keep repeating sex harassment just because I happen to be working on a lot of that. It's front of mind, but whistleblowing too. If you've got allegations that something inappropriate is happening and you can't confirm it completely, but you want to make sure you're being careful, consider separating people or taking steps to protect the complaining witness anyway, just to be safe. As long as it doesn't cost you too much, you may be saving yourself a world of pain down the road, financially and otherwise, by taking steps even where it's not fully conclusive.
So, and you bring up an interesting point, because for all three of you, what percentage, or like how often does it happen where you're investigating some sort of complaint, conducting an investigation, and other issues start arising?
I mean, it's sort of one of my favorite, truisms of employment laws. Like, half the time people come to me for X and I can't help them with that thing, but what I can help them with is something entirely unrelated that's not from the other thing that comes to mind for me is the movie. I make a lot of pop culture references, but the movie Goodfellas, Henry Hill, who went state's evidence. ESPN documentary I remember seeing years ago, where he was sort of allocuting or confessing to the FBI, and they went to him to ask him about one scandal or one criminal conspiracy. He goes, "Oh, you mean the point shaving thing?" So they thought they were talking about some theft or some grift, and he just by accident revealed that they'd been involved in point shaving and illegal gambling at Boston University or something, asking about something entirely unrelated. So by asking open-ended questions like that, you never know what you're going to stumble into if you keep an open mind and you're careful about how you frame things.
Yeah, I mean, my own estimate is maybe a little less than half, maybe like 30 to 40% of all investigations I do, that happens. So
yeah, and even to Max's.
Oh,
you go ahead, Helen.
No, you're in the middle of a sentence.
All right. Well, to Max's point, a lot of times, if I'm talking to, even if it's not a formal investigation, I'm talking to a potential client or a client, I'll have them word vomit a bunch of stuff to me. And during that conversation, there's a bunch of stuff in there they don't realize may have exposure. And the stuff they think is a legal claim probably sometimes isn't because they're not attorneys. So I think a lot of times you are going to get some information or nugget that is potentially a yellow flag that you need to kind of dig into and kind of figure out what's going on.
Oh, and you were going to add something, I thought.
Yeah, what I was gonna say is that sometimes the actual item that you're investigating ends up not being such a big deal, but what you find out during the investigation as to what other people may have done, their conduct ends up being far more significant. And then your investigation, you go back to, let's say, whoever is managing the investigation, especially if it's an outside investigator, what they're finding and say, hey, but this is what I found out. Do you want me to investigate this? And the investigation turns into something completely different. And I can give you, like, let's say an example, like two employees could be, you know, bickering about something. And, one employee makes, comments about, the company, and these two have tension. But then you find out when you actually interview one of the individuals that, let's say, the other person made comments to the extent of, they may have defamed the company, they may have put shared confidential information about the company, and you could be concerned about breach of a duty of loyalty or something, and the investigation takes a whole different turn.
And I think generally speaking, it's a good thing in reality, because it means it's allowing you to get ahead of a potential problem that is going to come, it's going to come down the road at some point. And instead of letting it kind of fester and then become a much bigger issue, you've gotten ahead of it and you've investigated it and hopefully minimize risk or exposure or other potential issues.
It's a value add proposition.
Yeah.
So,
So to Helen's example, if you find out during an investigation that, employee is breaching their duties or taking company information, etc., instead of having to wait for the employee to leave and then filing a lawsuit and going through all that headache, you're able to get ahead of it very quickly and kind of like stop the fallout. That's huge. That's going to save so much money and headache. And so that's another reason why you just want to be thorough in this process.
thanks, everybody. Amit, let's stick with you for the next question. Should there be different protocols for different types of investigations, and why? If so, yes, why?
Yeah, for sure. So you're not going to have a one-size-fits-all approach to everything. And we just talked too about how sometimes you start investigating one issue and there's other issues that come about. So it's like with shoes, you don't wear the same shoe to every occasion. I have multiple different running shoes, for example. So it's the same thing with an investigation. You will have to do one type of investigation if it's kind of more informal, which might be a situation in which someone there's a minor policy issue. Maybe it's not a big issue. It's just some small squabble. There isn't as much legal exposure to the company. It might not be as critical to devote a significant amount of resources to investigate that. But on the flip side, if you have a pretty serious allegation, either of a company policy violation or there's an issue of maybe the laws being breached or a huge component of potential liability or exposure, if it's a wage and hour issue, that could be a pretty significant hit if you don't investigate it, because that could lead to a class action or a collective action. And then you have someone like Max knocking on your door asking for a literal boatload of money. And that can make things much more problematic. So it just depends. I know that's the lawyerly answer, but depending on what the allegation is, that each situation is going to require a different level of investigation. And it depends on what the risk and the exposure is.
So one of the things I always talked about with HR management is this idea of consistency. How do you make the two, jive with one another, be consistent with one another?
Well, it could be consistent based on the type of issue, if that makes sense. So if it's a pretty serious issue, and I mean, that's kind of a broad term, but those can be consistently investigated thoroughly, where if it's not that serious of an issue, it's a small problem, that doesn't require the same approach. You're not going to always take a sledgehammer to all issues. It just really depends on what you're dealing with. And so not all things are apples to apples, but when it is a big ticket issue, a huge risk of liability, exposure, a harassment claim, wage and hour claim, a discrimination type matter, those things you can take a pretty similar approach to. But if it's more just like an interpersonal thing, that might be you may want to take a different approach, and that's going to be more productive anyways.
Great. So moving on, I think now we've gotten a lot of general or the core of like the general points out the way. Let's drill down a little bit. So Helen, we brought up
Yeah.
the before Farragher-Eller's defense, and I think that's one of the PowerPoint slides too. What is this defense? What does it mean to businesses?
So let me just tell you what fair girth alert is. It's not one thing, it's two things. It's two different cases that came out around the same time, both having to do with sexual harassment and involving supervisors. One involved a lifeguard, one involved a salesperson. And because they came out at the same time and their findings were somewhat complementary to one another, we now call it the Farragher-Ellerth defense. And here essentially is what it means, is that employers can be held liable for conduct by their supervisor unless you show certain kinds of affirmative defenses. And that's what we mean by the Farragher-Ellerth defense. Can the employer show that there are these defenses that would help them get out of liability when, let's say, sexual harassment or other inappropriate conduct took place in the workplace, especially by someone who was, let's say, a supervisor? So, for example, does an employer have a clear policy against harassment? Does it provide training on it? Does it tell its staff what to do in the event they are harassed? So for instance, in like a real world example, let's say an employee is sexually harassed by their supervisor, but they don't tell anyone about it. And let's say they quit and they sue for sexual harassment. Well, the company is going to be able to establish the Farragher-Ellerth defense because they're going to be able to say, hey, we have this policy against sexual harassment. We train people on the policy. The person who complained about the sexual harassment was at the training, signed a document, a certification that they were at the training. They know the training, but they didn't tell anyone. They know what our policy is, and they didn't complain to anyone. We did not have an opportunity, therefore, to investigate or to nip it in the bud. We should be held liable because we didn't know about it when that person had an obligation to tell us about it. So we could have done something about it. And if the employer has these kind of things on file and the employee doesn't take advantage of it, the employee could then be out of the box, even if they were, let's say, sexually harassed at the place of employment.
Well, thanks, Helen. Again, drilling down further, Max, we've discussed getting law enforcement involved. I think in the very first question you and I discussed, getting a little bit more detailed. And I know this sounds maybe a little stupid in some respects. I mean, because obviously there's some of the triggers, that's a bad word, but some of the indicators of when to get law enforcement involved are pretty obvious. But, what are maybe some of the more subtle indicators that law enforcement should be involved? And, also if you involve law enforcement, should you still conduct an in-house investigation?
Yeah. So, I mean, I think, you hinted at some of that, right? Depending on the nature of the employer you are or what kind of an organization you are, the law may flat out tell you in some circumstances exactly when you need to get law enforcement involved. If you're a youth serving organization in like any jurisdiction and there's some issue of employee abuse, sexual or otherwise, of one of your, charges, you're going to go to the authorities immediately because you're a mandated reporter, right? Or a mandated
Yeah, that's the term.
reporter.
Yeah, that's the term
Yeah.
that's used. Yeah.
Yeah. So, I mean, some of them are easy in that way, or if you're in some other industry where it's heavily regulated, the financial industry or Wall Street or what have you, and you see somebody engaging in insider trading or some other financial misconduct. And I'm speaking in generalities here because I'm not a securities lawyer, but, very likely you're going to have already existing regulatory obligations that require you to self-report as an organization or to go to law enforcement with certain information when you uncover it. But I think stepping back and thinking on a more macro level, you really ought to think about it as if you have some whiff of criminal activity, that's usually a good time to start thinking about that. If there's some indication that you're about to stumble into something that verges into the realm of criminal, whether at the state or federal level, you need to, I mean, consult with your counsel, but you really want to start thinking about getting law enforcement involved. You don't want civil or criminal liability to your organization resulting from your inaction or the perception that you covered it up or dragged your feet or impeded or obstructed an investigation or gave somebody an opportunity to destroy evidence or hide.
Or
And
loss of insurance coverage too.
yeah, I mean, criminal acts tend not to be covered, and if this is going to turn into a civil lawsuit to boot, that's a great way to ensure you lose coverage or a deck action by your carrier follows quickly with any civil litigation that jumps in. So, I mean, just thinking forward of some hypotheticals, if you have physical violence or credible threats of violence in the workplace, great time to call law enforcement. Worked on a case once where there was an employee alleging, he'd essentially been swatted by his company, and woke up to like cops with guns in his face. Come to find out from the employer, he was a veteran. He was also kind of a kooky guy. Him being a veteran had nothing to do with it other than it sort of fed their notion that maybe he had PTSD or he might have been a loose cannon in some way. He had allegedly been going around the workplace making a lot of statements that made people really concerned. And so it started off as a wellness check, but also as a, like, is this guy going to go on a shooting spree rampage? It led to some awkward conversations about that, but I think they were glad to have at least made sure that their workplace wasn't going to be in grave danger from somebody that multiple employees had
Yeah.
reported could be dangerous. You know, Thinking back to the example I gave at the beginning about a restaurant or bar that has a liquor license, if there's a sexual assault on premises, you know, and that you want to call law enforcement immediately. That's the kind of evidence that needs to be collected very quickly. You don't want it to get stale. You want to let survivors of sexual violence know they're supported and they're not going to be subject to stigma in the workplace for what happened to them, and that you're going to support them in pursuing the investigation and all of it, or at least in making it feel like a safe workplace for your employees, even when something horrible like that happens. If there's theft, embezzlement, fraud, other financial crimes, right? Like you don't want to let that stuff get off the rails. And very often when you uncover that financial misconduct, you're probably just scraping the tip of the iceberg. And it probably goes a lot deeper than you're really seeing at that moment. It's just the first time somebody got caught, not that it happened. Chuck hinted at this one earlier, illegal drugs on property, weapons. I mean, safety, I think, is usually a great indicator of we need to do something drastic here. But also, in this day and age, cyber crimes and data breaches are also a really big deal. People sense, I mean, how many hospital systems and other entities have been hacked by ransomware or other malware attacks that have had some real downstream consequences? And you need to let your clients, customers, patients, or whatever know. And you need to make sure that law enforcement, whether the FBI or otherwise, is involved and in on it. You can't be like, well, we can't let this get out. It's going to kill our reputation. It's going to kill it worse if it seems like you dawdled or dragged your feet or made it worse by sitting on your hands. Um, you also want to be mindful of red flags like evidence of intentional concealment or destruction of records. If people appear to be covering their tracks, you don't want to give them time to like get their ducks in a row and protect themselves. Um, and then lastly, to your question, Chuck, should the company still investigate? Yes, absolutely. But you do need to tread lightly, and it would be good to have counsel involved. And when possible, if you're able, try to coordinate with law enforcement or just make sure that you're not doing it in a way that can be seen to interfere with a criminal investigation, step on their toes, compromise evidence, jeopardize witness safety or credibility, or tampering. And also potentially you have the risk, and this kind of gets back to Upjohn, but any document you create in the course of that investigation could come back to you in civil or criminal litigation. So you really want to make sure you're working carefully with counsel that are trained in these issues, that are experienced in these issues, and that can carefully guide you through the civil and criminal minefield that these parallel investigations can create.
Great, Max. Thank you. I'm drilling down a little further now. We're actually doing the interviews. How do you document? What do you recommend as far as like statements, interview notes, things like that?
Again, it depends on what you need for the situation. You may want to get witness statements from folks that are signed or if necessary, notarize, that type of stuff. But it depends on if those things are going to be necessary for what you're looking into. For example, if you're in active litigation, maybe you do want to get sworn statements from witnesses. If you're not, then maybe that's not going to be as critical. You're also going to, when you're taking notes yourself as an investigator, if you're doing an investigation, you have to be thoughtful about what is a personal observation versus an actual fact and how that came together. And then there's other things to kind of look into as well in terms of what notes or information or documentation you need. You may need to ensure that stuff isn't spoliated if it's going to be potential litigation or stuff like that. So you may have to set out a litigation hold. You may also need to look at stuff that's not, you may need to talk to people who aren't witnesses and look at other types of documentation. So that could be emails, it could be text messages, etc. I think this can get messy because there's going to be some of the implications with privacy laws and people's personal space and personal property. So there has to be some art to how that's all going to be handled, and that's going to require outside legal counsel probably. But in general, I think you want to do a couple of things. You want to preserve the evidence that's going to be necessary, but then also, based on the needs of the matter, determine whether or not you need statements or report or other things for the purposes of conducting the process in a good way.
Thanks. Moving on, Helen, what do you suggest I'm sorry?
No, nothing. I'm ready. Hit me.
Okay. Yeah. What do you suggest relative to scheduling interviews or investigations and tips for preparing and conducting them?
So it really, depends on the allegations. If, for example, let's say the investigation stems from, a holiday party that happened, let's say at a restaurant or bar or outside venue, the investigator might even want to go to the venue or the location and talk to the people there and ask them, did they see anything that happened? What did they observe?
Film footage. I did that with a client of mine. Actually, it was a law firm. We were trying to get film footage of a law firm event at a bar.
Right,
They
exactly.
wouldn't turn it over.
I've been in situations with business clients, not even large, smaller business clients, where something inappropriate happened at a holiday party. We decided to hire an outside investigator, and our investigator decided to go to the scene and talk to the bartender and talk to other folks around to see what they observed about this inappropriate interaction that took place, and what they remembered. And that can be really helpful. So again, it's on a case-by-case basis. Depends on what are the allegations. If something in specific happened, where did that take place? So if something, let's say, happened at the place of employment, then you're not going to need to go outside the place of employment, but you need to find out everyone who was involved, who might have been a witness, and then talk to those individuals. I think it's honestly best to, if you can, interview someone in person. That becomes challenging when you have a remote staff and someone doesn't work in the office but works remotely. And in that situation, you might have to interview the person on Zoom, but definitely do it where you can see the person, see their facial expressions, see if they're thinking, how long it takes them to answer. Maybe you could tell if they're afraid to divulge additional information. There are just facial cues you can't get when you are emailing someone or when you're on the phone. So it's really important to have a face-to-face conversation. It's generally speaking, when I conduct investigations, I like to hear from the individual who complained first, see whatever the other witnesses will be, and try to talk to a number of individuals, sometimes before speaking to the accused. Because this way, if the accused, let's say, denies certain information or says certain information didn't happen, and you can ask that person, well, who would know about it? And if you knew that you already talked to that other individual who they recommended you speak with, and that individual has a completely different perception, then you are able to ask additional questions to the quote unquote accused that you could not have asked before. Sometimes you need to go back to the same individual after you've talked to other people. If, let's say, there are polls that you're getting and conflicting information, then you might need to circle back and speak with some of your other witnesses again. So, depending on the situation, you really have to tailor it to the situation. If, let's say, someone was really in a horribly, it has allegations of horrible abuse, and you have to be sensitive to that, and maybe do it even in a place that's not at work. We're not in a place where someone else is, going to see that individual and not know that they are the subject of an interview or an investigation. So you might really have to be careful as to where you're going to set that meeting, and you might want to do it in an offsite location or a location that is a little more comfortable, where maybe it's not in a private room with one person, but maybe in a more public place, like even a library might have a conference room where it's semi public. So it really just depends on the allegations, depending on who you are interviewing, and the how you set up the interview should be based on that. In general,
So,
though, most are not the extreme. So I'm sorry. Do you want me to
so
just finish
yeah,
my sentence?
I just had a question, and this can go to all three of you. And can you think of any situations, scenarios where you wouldn't interview the complainant first? I mean, I personally, I can't. I mean, nothing really comes to mind, relatively
The
speaking.
only the only time where I'd say maybe you wouldn't want to speak with the complainant first is that if the complainant provides such a detailed narrative and facts
Yeah,
are really very specific or clear, and let's say another individual is going to be leaving the place of employment or quitting or whatnot, and you're really in a hurry, you got to talk to that individual, maybe you would want to start with someone else first. But usually I would say, even if it's for a few minutes, I would at least start with the complainant to let them know that their complaint is being taken seriously, and this is who the investigator is, and that they are going to be setting up an appointment with them.
I agree
thanks.
with that, especially that last piece. I think at a minimum, even if you're not going to do the full interview with the complainant first, you at least need to like talk to them to let them know the process is happening. And then I think it depends on probably two things, what information you already have, but there could be logistical issues too. If it's supposed to be super expedited and you have to do some witnesses out of turn, I think that's okay. I know one person they actually prefer doing interviews over Zoom or Teams or video versus in person. I think they're in a minority on this, but their thought process on this is to a large degree what Helen was saying. They can just see body language and body movements and eye stuff
Yeah,
better because the screen is closer. So in their opinion, they actually pick up more through Zoom or Teams or a video call versus in person because they're just closer, like camera's closer. Um, I don't know. It's interesting. I've talked to other people about that and a lot of judges, and they're not in the same mindset, but I think there's some thought to that.
to me, it's a 50-50. It could go either way, most of the time. So,
Yeah.
thanks. So, Max, this is one of the more sensitive issues that comes up in interviews, and maybe one of the more difficult issues too. Confidentiality. Can you guarantee absolute confidentiality in an investigation? Even should you?
You can't and you shouldn't, is
Yeah.
the short answer. The longer answer is, I think, I think this notion of confidentiality is often a function of people's fear of retaliation, right? And a fear of suffering reprisals for telling the truth or implicating somebody who might appear powerful or a friend on the job. Um, so I think there's this balancing act, right? Because on the one hand, especially for sensitive topics, there's keeping things as confidential as possible within the workplace and limiting the scope of who knows that information and who receives it as much as possible. But there's no such thing as absolute confidentiality. As the employer, you have no ability to guarantee that something will never progress to civil litigation or criminal investigations. And you're going to lose the right potentially as a witness in some of those scenarios to just not participate. You don't have a Fifth Amendment right not to talk in a civil matter. And if there's a lawsuit, you can't just say, well, my boss told me it would be absolutely confidential, so I don't have to participate. That's not a thing, for lack of a better way to put it. So I think what you can say is we're going to internally keep this as confidential as possible. For the time being, your information will not be disclosed. But you need to make clear there is a possibility that stuff may at some point be discussed with some of the affected actors, but that it's not, we're going to take steps to protect you from retaliation, especially in sensitive matters that we're not going to go broadcast that we spoke. You can do things like what Helen, touching on what Helen just talked about, when and where you conduct these calls and investigations, meetings should be something you're sensitive to. If somebody has a penchant or reputation for retaliating who's at a relatively high level, don't interview your witness in broad daylight and, perp walk them past that person's office
Sure.
and with like blinking lights and bells on to let them know, hey, I know you're being accused of some stuff. Just an FYI, like, I'm bringing this witness in just so you know, like, don't do that. Um, you want to remind folks of the anti-retaliation policy, and then you need to take steps to actually enforce it. Like, don't just wait to see if they come back to you. Monitor it. Are they an hourly employee? Did their hours suddenly get slashed after they told you the source by somebody who might have been implicated in the accusations? Did they suddenly start getting negative performance reviews for seemingly no reason? Is somebody else, do they seem distressed or messed with, for lack of a better word, sort of out of the blue in ways that only became apparent after they cooperated? Don't just say we have an anti-retaliation policy. Take actual steps and tell them what steps you're going to take to make sure they're protected, and give them instructions on what they can do if they begin to perceive they're suffering unfair repercussions. Um, you also want to take steps to really make them feel safe enough to participate truthfully and encourage it. Explain the importance of the investigation, why this matters, why the truth matters, that you will require their participation, but that, unless they reveal like they've been doing coke in the bathroom at like a daycare center, or they're in on the criminal conduct you're investigating, if it's just simply they witnessed something and they've done nothing wrong, they're not going to get punished for telling the truth. And that's really critical. Um, and I think you always just want to be sensitive to how you handle this stuff so that um, there's no fear that the truth is going to get you whacked. Now, I will say, depending on the type of workplace you're in, there may be collectively bargain for union rights that give people the right to have union stewards or certain type of people with them for certain interviews. So you do need to be mindful of what kind of a place you're in. You need to be very careful not to mislead folks about what rights to confidentiality and otherwise they're going to get. Don't don't make that blanket promise. Use qualified language like we're going to keep this as confidential as possible, consistent with a full and fair investigation, and have policies for what that means. Who needs to know and who doesn't need to know this stuff? Don't give it to the gossipy employee in the copy room who has no reason to be involved in this, right? Like, that's not what you do.
Thanks, Max. Um, Keeping the focus with some of the focus on documents and records on it, what types of documents and records do you look for, or should you ask for both before starting and during the investigation?
So we touched on this a little bit. You're probably gonna have to look at emails. I think depending on the allegation, you may have to look at text messages or internal messages. Now, most companies, I think, have some internal chat feature these days, like Teams or
Slack.
Slack, whatever they're using exactly. So those at least are still company property, and you can look at those. If you have a company issued phone to your employees, or a company issued phone number, text messages are a lot easier game. I think where companies need to be cautious about what they're going to be looking at is going to be, and then I think you mentioned earlier, Chuck, too, video surveillance. I think you can look at, depending on your office setting and kind of where you are, maybe phone records, voicemails. The place to be a little bit cautious is going to be social media type stuff, because that can create a bunch of potential headaches. I also think companies need to be cautious about asking for personal emails, but it also depends on the allegations. If it's an allegation of sexual harassment or misconduct in the workplace, then those types of things might be necessary to figure out what exactly is happening. And to some degree, too, it depends on what the complainant is alleging, what they've shared, what they're willing to share, etc. But based on that, then you may have a better reason to ask for more stuff. But I think companies then have to be able to be careful with privacy issues and just not getting into a situation where they're opening themselves up to other potential problems. And I think to some degree, this also probably depends on the level of the employee being allegedly accused of the bad behavior, because the higher the level, the more likely, you have to look at potential text messages or personal communications to kind of figure out what exactly is happening.
You just raised something and a question in my mind, and I've never asked this of the three of you before. I don't think we ever brought this up here, but lie detector tests. Like quarterly, I think I get requests from employers about using lie detector tests. What opinions do you have of them?
I don't
mean,
know how reliable they are. I mean, I'm not in criminal law enforcement and I've never heard about anything like that, but it could also be an invasion of the privacy of the employee, and there could be other legal implications that could arise. I don't know. What are your guys' thoughts?
Yeah, that's my gut reaction too. Is I'm not sure they're really that reliable, so I'd want to be careful about that. One thing I forgot to mention though is you, as a company, depending on the claims, you may also have to image devices just to preserve it from a spoliation situation. But instead of a lie detector test, I'd rather just get the data or the information or the messages, because I don't
Well,
know
you have the
how.
forensic, yeah,
Yeah,
with what you're talking about, the latter, you have the whole forensic chain. Whereas with the
exactly.
lie detector test, and I represent solely employers, and I don't recommend lie detector tests because of the whole chain of the process of the gathering of the evidence, the techniques and methods they
Yep.
use. Very similar, in my opinion, to like asking for biometric data.
Yep. And I think this is also, I know companies are kind of hesitant about the cost, but this is a good example of why it makes sense to give employees a company issued computer, or definitely computer, but phone, because then there's a better argument to say we got to image stuff, we have to look to messages, even if the employee put personal stuff on there, because it's a company device. And then Chuck, to your point, that allows you to do more forensic analysis to kind of figure out what's going on.
Yeah, and it's more valid. I mean,
Yeah,
it's easier to prove the validity of it.
exactly.
Thanks. So, Helen, how do you wrap up an investigation? Once how you conclude it?
So what the investigator should do is the investigator should look at all their notes from the various witnesses with whom they spoke and whatnot, and write out a summary. And the summary should really just stick to the facts. The summary could also take into account the investigator's observations. So for instance, let's say a specific question was asked, and let's say the person raised their eyebrows, or they appear to start sweating, or something really odd happened. The investigator can note their observation in, let's say, the report. And then at the end of the report, after the investigator summarizes their findings, the investigator should give an opinion as to what they believe as to credibility. More likely than not, I feel this is what happened, or this is what happened, and here is my reason for that opinion. The investigative report should not go into anyone's personnel file. It should go in specifically an investigative file. After the investigator summarizes their findings, depending on what those findings are, there could also be recommendations from the investigator. So for instance, the investigator could say, oh my God, this is, like a bomb waiting to blow up. Get rid of this person, Or the investigator could say something like, it really wasn't such a big deal. Yeah, maybe this comment was said, but, I don't think it rises to the level of, let's say, discrimination. It may have just been an inappropriate conduct. Even so, someone shouldn't go around making these kind of comments. So maybe the person needs some training. Maybe they should, and maybe the investigator would recommend certain kind of training. And so then once the investigator has the investigative report and it goes into the file and the company understands what they want to do, they should have some kind of an action plan. They should speak to the individual who made the complaint, let the individual who made the complaint know that the investigation was concluded, and summarize the findings of the investigator, and then let the person know what is going to take place afterward. Remind the individual that there is no retaliation and that they are not going to be retaliated against for making a good faith report of whatever it was that they made, and that they shouldn't suffer any retaliation as a result. If, let's say, someone is going to be disciplined for if there was misconduct and someone is going to be disciplined, you can let the individual know that we have decided that X, Y, and Z, it was inappropriate what X, Y, and Z did, and that individual is going to, go for training. Or sometimes it could be that these two people, if their offices are near each other, their offices should not be near each other. Maybe someone needs to be moved. and let the person know that, you know, these are our recommendations and this is what's going to take place afterward. And then obviously you need to have a conversation with the accused as well and let the accused know that we concluded our investigation and either there is some, let's say, inappropriate conduct and what it is and how that person is going to be disciplined. Maybe a memo needs to be written and they need to sign the memo that they received information about, you know, the discipline and what the corrective action is going to be. Or it could be that someone needs to be separated even. And then you decide whether, you know, you're going to separate someone with, let's say, a separation package.
Yeah, firing, by the way, not separate, like in a separate part of the building or
Right, you're
something
going
like
to
that. Yeah.
sever, terminate, whatever, you know, some folks want to call it. Or just that this was so, you know, horrific that's it, they're out. I mean, it could be that the investigator comes back with their report and you realize that this is awful, we cannot let the person stay. And that's it, they're cut off, you know, their access is cut off and they're walked out the door, you know? And so it, you know, essentially it you know, it depends what happens and what the investigation finds, but at a minimum, what usually does happen, any sort of an investigation, there should be some kind of documentation about the investigation, what the findings were of the investigation, and then what, if any, action took place as a result of the investigation.
So we've only got a few minutes left. What I'd like to do is to post all three of you. What about retaliation and what do you do about it? And especially relative to witnesses, because witnesses, you know, a lot of workplaces there's gossip and things like that, and witnesses may be confronted, or people may try to compromise them. What signs do you look for relative to retaliation, and how do you deal with it?
I mean, you have to remind, you know, people, especially like, let's say the quote unquote accused. So let's say the accused really didn't do anything wrong. Well, there's going to be some kind of tension, and that person probably is going to have an educated guess as to who the one was who made the report. And you're going to have to clearly instruct that person. Listen, we remind you, you know, just because you might feel a little bit uncomfortable and just because you knew we had this investigation, we have an anti-retaliation policy. You've got to get right back into business as usual. And you have to be very careful not to take any retaliatory steps toward the individual who may have made the complaint. You have to let the person who made the complaint know.
Yeah, what are the steps? I mean, usually you look for like an adverse action to the person alleging retaliation. I mean, so what do you look for?
I mean, you could, and I think I touched on some of this earlier, but like it really depends on the workplace. But look for changes, look for stuff that's new. Is it an hourly employer? Is it somebody who's scheduled a set number of hours in comp? Do their hours suddenly get slashed? Is it somewhere that, you know, conducts performance reviews? Do you have a successful employee with a stellar history who suddenly is on a PIP and can't do anything right, you know, has been written up and suddenly has poor performance issues? Are you loose on attendance and is suddenly on a final warning because they're 30 seconds late? I mean, I had one recently where somebody went on FMLA and they came back and they got fired over clocking in. I think it was like 9 seconds early. It
Right,
was,
Jesus.
yeah, like a week after she returned from an FMLA leave and a surgery, where it was like, this has literally never been a problem before. You've always adjusted my punches if I'm quick on the draw. It was clearly an accident. I wasn't stealing time, and we've been here for years. And it's like, well, you were 9 seconds early, you're fired. And it's like, well, I mean, it happened technically, but it's never mattered before. So I think the long answer to the short question is look for deviations. Look for things that are suddenly out of the ordinary, changes in that person's personality. You know, if they report directly to the person they were honest about, is that person suddenly getting belligerent with them? Just look for changes. Look for something that seems unique.
And we mentioned this on other podcasts, but the Supreme Court came out with a decision about a year ago, Muldrow, which has changed and broadened the retaliation standard in employment settings. And so I think because of that, companies need to be extra cautious, to Max's point, about any change. I think it's a broader interpretation. So what's retaliation now is a lot easier for an employee to establish. And so just be extra diligent about that.
Yeah, I know in litigation used to be more difficult to establish retaliation or retaliatory behavior, and it is broader now, probably for a good reason too. So,
Yeah.
all right, is that nothing else? We're at the top of the hour. Thanks everybody. That was a great discussion. And this concludes today's webinar. We're going to be back for the 6th webinar in this series. It's so hard to say goodbye, minimizing risk when terminating employees. And that's going to be on July 10th, coming up in a little more than a month. So we'll see you guys then. Take care.
Thank
Great
you.
job. Thanks.
Bye, everyone.
Thanks, Chuck.